Hi, everyone. Good afternoon and welcome. Today we have a special guest, Sandra Giudici, who is a CDFA and Chartered Special Needs Consultant and founder of Financial Insights, which is based out of Cupertino, California. Sandra specializes in enabling clients to make better money decisions through financial analysis and life-centered planning. She specializes in life transitions and special needs financial planning. So today she's going to discuss with us what it's like divorcing with a special needs child. Welcome, Sandra.
Thank you, Sonia, and thank you for the nice introduction. Welcome, everyone. I appreciate your joining me on this webinar, and I hope that I will be able to answer and address a lot of the questions that you might have. There are many different stakeholders that will be listening to this even afterwards who are not in attendance today. So I'm going to be covering very different domains of what it takes to divorce with a special needs child. And that would cover domains such as not only divorcing, but the emotional side of it, the educational side of it, the estate planning and tax planning. And so there are many different facets of divorcing with a special needs child. The presentation does not constitute legal or tax advice. It is for educational purposes only, and hopefully I'll be able to address any questions that you might have at the end. There'll be a few minutes left remaining for us to go through that. This will be kind of a fire hose of information, so there's a lot of material to cover. I speak pretty quickly, but hopefully you'll have all your questions answered, and it will be somewhat, you can review it later too if you have any questions or need any clarity. So we're going to start with what are special needs. Special needs for the purposes of divorce are a little broader than what would be specifically qualified for a special needs as a disability. But it runs a spectrum everywhere from ADHD, ADD, to learning disabilities such as dyslexia, dysgraphia, to developmental disabilities such as autism, cerebral palsy, or Down syndrome, intellectual disabilities, physical disabilities such as a blindness or a loss of hearing, and then the extras, which are mental illness and or addiction. So those are the two extras that I'm throwing in there for divorcing with a special needs child, because it does require additional complications and additional attention during the divorce process. Because of the variety of special needs that are considered, there are many different interventions, and every individual is, every single disabled child is an individual. So they may have a particular diagnosis, but also several other comorbidities along with that diagnosis. And those comorbidities might complicate the whole issue. So you've met one disabled child, you've met one disabled child. They're not the same across the board. It is not like you can throw them all into a kindergarten room and they're all the same. And that's because they all have different medical issues. They might have different medications. They need behavioral therapies or speech therapies, physical therapies, occupational therapies. They might need genetic testing because they're on medications that might not work for them because their brain chemistry is different and they react to medications differently than a typical child. So genetic testing is often recommended. Of course, genetic testing is not covered by insurance, and you don't probably want it with your insurance anyway, but that might be another complication or addition for a special needs child to be considered in a divorce. Psychological therapy, psychiatric therapy might be warranted for any of these children. There's specialized transportation that is required for certain physical disabilities and or intellectual disabilities. And then there's alternative therapies that are not covered by insurance, but are warranted and might be beneficial to the child, or at least some parents might think that they might be. And those would include craniosacral therapy, hippotherapy, aquatic therapy, oral motor therapy, massage therapy. So it goes on and on. The life of a child in a family with special needs is much more complicated than any other family. And other families are considering, well, what extracurriculars are we going to put our child into? And in our Bay Area, we have many different extracurriculars because we overscheduled our children. But these types of therapies are therapies that evolve through the years, change through the years, and you have to consider that they might be warranted at any point in the childhood, during childhood or adulthood for that child, and you have to plan for that. So it's very important to understand that there are a host of and a myriad of different interventions and special needs. And along that line, the financial considerations of those interventions is extremely important. So this is about the financial consideration involves both temporary support. So when you're in the pendency of the divorce, the temporary child support, as well as the permanent support. The key to ensuring that you're covering all of that is to have exquisite and definitive expense tracking for that child, so that the parents understand what they're paying for and not getting reimbursed from insurance, not getting paid for by the school district, not getting reimbursed from the government if they're getting any governmental aid for a minor child or an adult child, and any other special considerations that you need for add-ons in support. So it goes beyond the guideline support, and because of all these additional needs and all these additional financial considerations. In California, Family Code 4062 does provide for that. It does state that the reasonable uninsured healthcare costs would be provided under Section 4063, and also costs related to the education or other special needs of the children would be provided as an add-on in addition to the guideline support. You need to check with your state to determine if this is applicable within your state, but it is covered under California law to provide this other extensive financial support for the child beyond guideline support. The emotional toll of special needs on divorce is unparalleled. Everybody coming into a divorce it's an emotional time for everyone. But for a family with a special needs child, they're coming to you already exhausted. They've already fought or battled the medical industry, the insurance industry, the educational industry, the third-party providers such as behaviorists and that industry. And now they're coming into the divorce realm where they have to deal with yet another issue on their plate. So the toll is very great. But I do want to debunk one theory. There is a theory out there, or a misnomer, that was based on very small studies that were done a while back, that 80% of all families with autism end up in divorce, and that has been debunked. The Kennedy Krieger Institute and Johns Hopkins University conducted a study of 78,000 families with children with autism, and they found that some of them, 66% of them, lived with biological or adoptive parents. So 40-some% were divorced. So autism either brings a couple together and makes them stronger, or it can tear them apart and cause be a symptom to cause divorce. Now, the severity of the autism does not have any bearing on whether or not the couple would divorce or not, but there's stressors anyway. It doesn't really matter. It's a huge strain on the marriage, whether or not they're high functioning or low functioning autistic. So this was one study done on one type of disability, autism spectrum, but it probably applies to many of the other disabilities across the spectrum. So you're going to see divorce rates happen probably a little bit higher rate, but it's not that 80% rate that that is kind of the myth that is floating out there. Special needs does have a tendency to exacerbate the divorce process, though. So not only are they exhausted before they get to the divorce and they start the divorce, but extra counseling and support is warranted during the divorce process. And the reason for that is that there's greater pressures and worries. The parents are constantly interacting and dealing with the children and their support system, and also the network for that child, whether it be educational, consultative, social skills, medical, whatever it might be. There's always greater care, greater worries, greater interactions with others. So with these pressures and worries, now you're adding on another layer of the divorce. And that causes a lot of consternation during the divorce process. And it could also exacerbate the conflict that goes on in divorce and requires a lot more compassion and a lot more understanding. So I just want to impress upon you that that is one thing that I've noticed. So what I do in my practice is I'm available on weekends. I'm available after hours because that's the only time, as I know, parents with a special needs child are available to talk. They're not available during the daytime. Typically, they're not available when the child's awake. So it's only on those off hours that they can finally concentrate on what they need to concentrate on. So just to enlighten you, that might be something that you might want to expand or adapt in your practice at some point. Typically in a special needs family, one parent is the primary caregiver. Now, this might happen in many other regular typical families, but in a special needs family, there has to be a point of contact with all of these other providers, with the medical industry, the education, as I mentioned, the behaviorists, whoever else is interacting with the child. So typically one parent does become the caregiver. Typically one parent has to relinquish a position or a job in order to deal with that on a more full-time basis or on a more regular basis. Not always, but oftentimes this is what happens. And that parent becomes the architect of care for that child. With that title, it means that there's a little more boundary. There's a little more, the parent who has kind of read up on all the literature, spoken to all the doctors, intervened with everybody, and knows the child the best because they're with them all the time, might not be as willing to share all that with the other parent if the court gives 50-50 custody, for example. So there are implications to work around because one parent is really containing a lot of information and a lot of knowledge and a lot of expertise around the care of that child that the other parent might not have. And to give you an example of this, I have one client where the child does not speak. He's 10 years old, and they have a 65-35 split custody, physical custody. The dad never learned to use the assisted device to understand the child in speaking. So the child's 10 years old. He spends 35% of the time with the dad. They bring in a babysitter during that time, and the dad has never learned to talk to his child. He knows basic things like I need to go to the bathroom and I want to eat, or I'm sleepy. But that's about it. That's all the dad can do, can interact with the child, and he hasn't taken the time to learn anymore. So this is kind of could be common with these children, and it needs to be incorporated and understood in that whole realm of defining custody and what is in the best interest of the children during a divorce process. The implications involve scheduling, it involves financial, it involves interpersonal relations. So there's just so much more in the custody consideration that needs to be taken into consideration beyond working with regular children, regular families. There's oftentimes some parents disagree even on the diagnosis. So there's a reluctancy or a denial of one parent in many of these cases about their children and whether or not they really do qualify as dyslexic, or whether they do qualify as autistic. Now, you wonder how that could be, but it can be. And often one parent agrees and the other parent disagrees, even at the basic level of diagnosis. But then they would disagree, even if they agreed on diagnosis, the treatment. They don't like the particular therapist. They don't like the psychologist. They don't like the psychiatrist. They don't like the meds that they're on. And the other parent thinks that this is what needs to be done, has done all the clinical analysis. And so on and on, the conflict gets heightened, the conflict gets greater, and it becomes a more contentious divorce, a more costly divorce because of these disputes and because of these escalation and conflicts. And this is just what happens because the child does not stay the same. What is a child in preschool is not the same. That any child does not stay the same. They're all growing through the years. But with the special needs child, the preschool special needs child is not the same as the elementary school child versus adolescence and teenage years. And comorbidities might be added on through this period of time. In fact, the comorbidities might supersede the diagnosis as a greater problem. These comorbidities might be anxiety, they might be OCD, obsessive compulsive disorder. It might be all sorts of things kind of come out later on or evolve later on with these children. So it's a continuously evolving kind of continuum of disability. And there's disagreement that comes along with that, of course, then, because how do you treat that? How do you approach that? If one parent decides they don't want to follow the ABA therapy, for example, of giving positive reinforcement constantly of candy or toys to the child and stickers or whatever it might be, and the other parent says, no, this is what the ABA person has informed me about. The ABA person does not want to come between the two parents. They will not necessarily, they do not want to speak to both parents. They want to work with one parent, and they expect that parent then to communicate to the other parent. So is the continuity of care the same when you split them up into physical households? That's another consideration to work into your agreements and work into your counseling throughout the divorce process. So the legal custody issues involve education, extracurricular, medical decisions that arise that you're constantly involving. You might be in 4 different schools in elementary school. It's not just one elementary school. You might be deciding between a regular public school versus a non-public school. So all of these issues and decisions have to be made from a legal custody standpoint that you don't typically, usually you sign up for a school system, they're there from grades K through 6, then they go on to middle school and they go on to high school, and that's your school district and that's it. For the special needs child, you might be traveling 20 miles to go to a school, especially for dyslexic children, or for ADHD, or for autism. Or they might be going away to boarding school. So there are many different opportunities for decision-making, for conflicts, for disagreement, and also from the physical custody standpoint. Children who are, for example, on the autism spectrum are very ingrained with routine and regimen and parental attachment. And typically it's one parent that they're attached to. So once you start changing or modifying that, then they could be they could experience regression. So now you have to bring them along that continuum to get them back up to the place that they were once the physical custody things are worked out. So it's difficult for any child, of course, right? But for the child with special needs, it could be a greater concern and exacerbate their development and their what's in their best interest, and needs to be considered as well. And then this leads to many different, much conflict, many decisions, many disagreements. So often it's wise to consider a third-party intervention earlier in the divorce process than later. And that in California, it could be a co-parent or it could be a minors counsel. I know that you call them something different in different states. I spoke to somebody in Florida, and there's a different name for that. But it's a third party who might come in and help you make those decisions or help mediate those decisions, or even be an arbitrator of those decisions when the parents conflict. Because I have a client whose child was, the mom decided that she didn't want the child receiving ABA therapy anymore and canceled the therapy. Well, the dad was really upset because he said, now it's going to take 6 months to get back on the wait list, to get off the wait list, to get back to that therapy. So the child's going to miss 6 months of therapy in elementary school years. Because the mom didn't want to deal with the schedule on the behaviorist therapy. And they really like that particular behaviorist. That's another thing. The children tend to have special affinities towards certain people than others. And so sometimes that also mitigates it. So, or exacerbates what the problem is in not having a continuity of care, not having consistency. So these are all issues that really need to be considered during the custody part of divorce, and how to resolve those issues. It could also go in terms of an individual educational plan, the IEP, and the school district. Who's going to be on the team for the IEP? Are both parents going to be there? Do both parents agree? If they are there, if they're not a unified front, that school district will not be delivering any care to that child because they don't want to deliver it anyway. So the parents need to be together and be aligned on that, or bring in potentially a special advocate, which is another third party to help mitigate that and is costly, or a special education attorney, and that has been dealt with before on these IEP teams. So these are all third parties who might be able to help mitigate issues in a divorce process when you're dealing with the custody, the legal custody. Also from the physical custody standpoint, if there's modifications to be made to a house, who's going to pay for those modifications if the child is now split in 2 different houses, potentially adaptive furniture, and then respite care. Some respite providers will not travel beyond a certain distance. So if you're getting respite care from the government, you need to ensure that you can have that respite care go to both parents' abodes, and then there's specialized child care. Some babysitters do not want to deal with special needs children, or if they do, they can take them only for so long and then they don't stay with that process. So there's always an extra vetting going on, extra connection that you have to make, and you have to have the child, as I said before, they are very sensitive to who it is that is providing to them. So that's another concern as well for physical custody. The educational concerns, as I mentioned, the IEP team, but also aides. There are aides that are potentially provided with the child in the school environment. And if there are aides, then who's going to be vetting that aide and working with that aide and communicating? And if you're going to communicate one thing that says, yes, if she does not attend the reading group at this time, then this is what I agree that you should do with her. And the other parent says, I disagree. I think you should be doing this other thing with her in order to get her to join the group. Then you have a conflict again with the aide in the school system. Tutoring becomes another issue. Is the tutor, sometimes tutors don't want to go to different homes. They want you to bring them there. And there has to be a very specialized tutor for that particular child, oftentimes. And if the child is having issues, so who's going to vet that tutor, and will that tutor be able to go to the different homes and work with that child in those homes? And then I mentioned the private school, and also the advocates and special education attorneys. So that handles the education side of it. Now we have the social side of it. And for many of these children, they're involved in social skills classes. So, and they're involved in specialized play dates. Sometimes it's often recommended that you bring in a third party to facilitate a play date, and the play date might be with a neurotypical child and an atypical child, and that facilitator has to go then to 2 different homes, or might not be amenable to doing that, I don't know, but is the child able to go to the other home, because you typically want to have consistency with the play dates. This is not just regular, go down the street and play with somebody. So this is all facilitated, scheduled, and all just complicates things a little bit more in a special needs divorce, and really needs to be considered. And the same thing for camps, specialized camps that only happen at, on the 3rd week of July every year. And if that's somebody's custody week, then are you going to be willing to give that up because they can't go any other time? It's not like go to a different soccer camp or a different dance camp. So that's another concern, is to be able to prioritize what the child needs in all of these custody considerations. And then who's going to be accompanying the child to the camp, and who's going to pay for that extra cost, and will both parents agree to send the child to that particular camp, and is it worth it, and all these other decisions that come along with that. Anyway, that's part of that. We're going to switch gears now to more financial side and consider the tax considerations. Oftentimes built into all these child support issues are tax credits. The child who gets the pillow test, right? Who is going to get the tax credit for the child for the extra day that they're at that home? Well, if you're qualifying for a child tax credit, that would be a $2,000 credit on an annual basis. In the Biden administration, he's proposing $3,000 per head. So this is for typically children under the age of 18. Under the age of 13. So it's all children 0 to 12. But for a totally and permanently disabled child by the Social Security stringent definition, there is no age limit. So this goes beyond age 13. So you have to consider that child tax credit will be carried forward as long as they meet the other 3 prongs of that test of relationship, a child, abode, that they're living at your house, and that you're still supporting them more than 50% of the time. So those qualifications need to be considered from a tax implication and financial implication in the divorce with a special needs child. One really big element that is often overlooked is the medical deduction that could be taken for the children. And we're not just talking the health care that is unreimbursed and those types of things. The medical umbrella is varied for any child with special needs. There might be medical expenses and prescription drugs, but also housing accommodations and specialized education schooling. So if you're sending the child to a specialized tutor, as they're going to a special school, a non-public school that's not paid for by the school district, if you are attending conferences for the child to learn about their disability, all of those different elements are considered medical umbrella and could be deductible by the parent who actually expends the money for that. Well, then you say, well, that's easy to handle because you can just split it down the middle and both parents take the deduction, but it doesn't work like that. The IRS says it has to be greater than 7.5% of your AGI, your adjusted gross income. So if you're splitting households and you're splitting those expenses, you may not have enough to be greater than that 7.5% of the AGI. So guess who wins? The IRS, if that's how you're going to split it. Instead, you should consider the idea that you should funnel all of the medical expenses to one person who paid for it, because it can only be given to the person who actually incurred the expense. And that deduction can only be given to that person, but it has to be greater than 7.5% of the AGI. So in order not to make the IRS the winner, in order to take advantage of the deduction for those medical expenses, which could be insurmountable, that could be pretty great, because I didn't go into all the details of everything that they can include. But as you can see, you can really add up those deductions, and they should be considered during the divorce and during the MSA or marital settlement agreement. Take that into consideration. Of course, taking into consideration that if there's a reimbursement for it and you're not going to take the deduction, that becomes an add-on and there's a reimbursement for that, for those expenses that are incurred by the parties. And you also might want to do the swapping, just like you do for the head of household test in the MSA, that you might say 1 year you claim and 1 year I claim. So there are many different variations of this, but it should be considered as part of the MSA and part of the support that is being offered. Adult child support varies by state, as I've been kind of speaking to California, but it does vary by state. Most courts do say, and most states say, parents have the duty to support their adult disabled child if the disability occurred before the age of majority, which varies by state. It could be 18, 19, 21, depending on your state. Few states will not impose an obligation on the parents. Why is that? Because their intent is so that they don't have to pay for the child's public benefits to support them. So they don't follow the SSA, the Social Security Administration's stringency test when it comes to them having to pay for public benefits. No, they're wide. Any disability counts in this respect because you're now obligated to pay for that child and they don't have to pay. So for the states, the statutes are more broad for the parent to be the supporting parent. Some states even have filial support, which means that siblings must support other siblings and children must support parents. So it depends on your state's statutes as to who has the obligation to pay for an adult child or an adult who is in need. And it's determined by the state's guidelines. It could be statutes, it could be case law, or it could be both. In New York, there's very limited circumstances, for example, where they would award adult child support. So it's very narrow. In Michigan, there is no statute or any duty to support under any circumstances unless there's agreement between the parties. In Maryland, it requires the parent who is capable of earning sufficient means to provide food, shelter, care, and clothing for the adult child. In California, we have Family Code 3910. Parents have the responsibility to maintain a child of whatever age who is incapacitated from earning a living or without sufficient means. And of course, the definitions of those two prongs are evolve into court decisions, right? Into much potential for conflict and disagreement and definition, etc. I also have a link that I can put into the chat box, and you can check your state statutes as to what your state requires for once the child reaches the age of majority. Oh. There we go. All right, so you can check out your state statutes there. Public benefits could be anywhere from supplemental security income, SSI it's called, and they do not offset the parent's obligation for support. So anything that you receive from SSI is not offset by whatever the parent might give you as additional adult child support. Now, the amount that the SSI is set at a federal level. It's $794 per month. So that equates to approximately $10,000 a year. Once you add on the state support, because the states all give a little more onto that. In California, it would be $910.72 per month. That's supposed to handle housing and food and shelter for the adult disabled child. $10,920 a year. If anyone thinks that you can live in California on that amount per year, you have another thing to consider, because it's virtually impossible. And all the other states is probably lower than that $116 extra the state of California adds on to the federal amount. So this $794 would never change, even if the child did receive adult child support. However, if they're receiving Social Security and Social Security disability income, then it would offset the parent's obligation. I'm sorry, I said something wrong here. The SSI does get affected by adult child support. It doesn't affect the parent's obligation. So we're going to talk about the child support in a bit, further on in the conversation. But the Social Security and Social Security disability income is what you pay from your paycheck into the Social Security system. It's insurance. Because you've already paid it in, then the government says you can offset your support obligation because you've already paid it into the system and the child is receiving Social Security or Social Security disability income. When does the child receive that? Only upon your death, your disability, or your retirement. So the parent would have to die, be disabled, or be retired in order to get those benefits. Typically in these divorce processes, in gray divorce, you might run into that because they might be on the verge of retiring or or they might have disabilities, or there may be a death. So that's when the child might be able to partake in those disability benefits. And if so, it would offset the parent's obligation. So here's an overview of what the family law implications are for an adult disabled child. First, there's the life care plan that needs to be done to identify the income the child might be receiving. Sometimes they're working too, so they can work up until a certain amount and not lose their benefits. They would also have cash flow expenses. So it would be housing, their subscriptions, we'll get into all the different living expenses that they might have. So you have to take into consideration a 60 to 70 year period from the time the child is 20 or so till 95 is now the length of time the actuaries are using for your length of living, your standard. So you not only have the two parents and their retirement concerns to be taken care of, but also you now have the child, the adult disabled child. If you think that the child is going to be, that's in the divorce situation, is going to be hampered for life with that disability, then you have to consider the entire lifespan of that child going forward from age 20 on. And in order to do that, you have to consider all the potential expenses that might be incurred through the lifetime for that child and the government benefits that might be paid. So this takes a lot of analysis and calculation if you're going to submit a motion for adult child support. In some states, the motion for adult child support has to happen before the child reaches the age of majority. Otherwise, involved in the family court. That is the case in California. They have to file during the year the child is 17 or so. Otherwise, you cannot get that agreement from the court, the family court. The child support beyond guideline formulas and add-ons need to be considered. Life insurance might be used to fund child benefits once you've deceased, or you might pay. You might also consider retirement benefits. So now with the Secure Act that happened in December of 2019, it never used to be a good idea to grant the child with a disability the retirement benefits for the RMDs that are coming out of the retirement programs of 401ks or IRAs. But now it is more beneficial to the child, to this adult disabled child, to be a beneficiary of those programs. And the reason is because there's a 10-year limit now on dispersion of those funds once you've died. So if the spouse has died, they have 10 years to deplete the funds. With a child with total and permanent disability defined by the Social Security Administration, which is a very stringent test, the child would be able to live off of the RMDs for the extent of the child's lifetime. So the RMDs would be distributed at a much lower rate because they would be prorated over the child's lifetime. So it might be beneficial to consider that as you're doing the division of assets and deciding who's going to be beneficiaries on various assets, or putting it into the MSA that some parent has to name the child as the beneficiary. So there are many implications that this involves. Estate planning. Estate planning is a really huge issue and should be considered while the parents are still in this discussion phase. Who is going to be the conservator if the child is qualified to have a guardian or a conservator? And if they're not qualified for that, then who will be granted the durable power of attorney, the general power of attorney, or the power of attorney for healthcare? So you can only name one parent for each of those. So again, it's the who is going to agree on that, and who will help them agree on who will be named in those situations. And you might want to incorporate some of this into the MSA, even if the child's not there yet, just because you're in the divorce process and these things might have to be ironed out later and they don't have to come back and be decided, or they should really be decided during the course of the divorce, but that would depend on any individual circumstance. Parents might have communication for the rest of their lives together now. You can have a nice clean break and there's disentanglement and everything else that comes with divorce, but for parents of special needs children, they might be entangled for life. And so then it might behoove something in the MSA to establish a practical process for arbitration later, or using a relative, a medical professional, a friend, a special advocate, whatever that process might be, because there will always be something that comes up that they might disagree on going forward with that child. And unless you've given clearly the responsibility to one parent versus another to make those legal decisions, and that's another way to handle it as well. And then you have to assign who's going to be responsible for the intervention or intervening with the government or with the government benefits, intervening with the medical needs, as I said before, with the durable healthcare power of attorney, or any potential legal decisions or legal issues, such as civil rights attorneys that might come up, or whatever might come up during the course of the child's 60 to 70 year lifespan. Housing authorities, I mean, it goes on and on. So you really have considerations for a much longer period and much greater and complicated situations. The division of assets also involves, in the divorce of the special needs child, potentially dealing with the child's UTMA account. So often children are given accounts when they're born, and you may not discover the special need till later. And these UTMA accounts and gifts are piling in, so the child gets a substantial amount of money by the time they turn the age of majority. Well, once they achieve the age of majority, they will not qualify for government benefits if that is left in their name. Typically, there's one custodian in charge of that account, but at the age of majority, the child has access to that. So those accounts would have to go into a first party trust because they are owned at that point by the child. But if they don't go into a first party trust, they would potentially compromise their qualification for government benefits. You can only have $2,000 in assets, one car and one home in order to qualify for a government benefits. So if the child has an UTMA account of $5,000, they wouldn't qualify. So you'd say, well, okay, so the child's going to lose $794 a month. So who cares? Well, it also means that they would potentially lose Medicaid. And as I described earlier, Medicaid handles housing, transportation, day programs, therapeutic care, all kinds, social skills programs, etc. So Medicaid covers many, many benefits. I have one client who has 24-hour care through Medicaid. That's just companion care, caregiver care, because he needs 24-hour care. He's 30 years old, and that it runs up. The cost for his care through Medicaid is $140,000 per year. So you don't want to lose those benefits. Even if you lose the $794, that's not a big deal, but the Medicaid might be a big deal for that particular special needs child. Now, not all of them qualify, not all of them will get that, but it depends on the situation. So you'd have to really concern yourself in the division of assets is what's happening to that UTMA account and how will you handle the money in there. Same thing for a 529. Now for 529 accounts, they just passed the law about a year ago that you can now transfer the 529 to an ABLE account, which is Achieving a Better Life Experience account. It's an account for disabled people by the federal government. And you can transfer $15,000 a year into that account. So you haven't quite lost all your 529, but you might want to consider reevaluating that 529 and deciding how you want to handle that, whether it be for other typical children or keep it for that child and disperse it $15,000 a year up to the annual gift amount exclusion. Which might be changing, by the way, under the Biden administration. There might be a limit on that might be $50,000 maximum that can be given out. And so you have to really consider all the implications of what regulations might change and how that would impact what you do with these accounts that have been previously established in the division of assets category. The government benefits are for SSA. If the child is receiving any adult support, they will lose 1/3 of their government benefits. The Social Security Administration excludes 1/3 of the benefit and says, okay, you can keep 1/3 of that. We're not going to touch it. However, 2/3 of any unearned income, and that would be considered unearned income because it would be child support given to the child, would be offsetting dollar for dollar reduction in any federal benefits received, less $20, which is just an anomaly that they throw in there. It's called a general income exclusion. So anything beyond that $20 would be offset, the government aid would be offset by the child support. So that's why it's very important to consider a first party trust, also called a self-settled trust, also called a D4A trust, for the child support payments to an adult child in order to preserve the government benefits. Otherwise, 2/3 would be completely offset by that. Moving on to the cash flow analysis, as I said, that you have to do the life care plan. There's the income that the child might be making from wages in the future, potentially from the child, from government benefits, and from whatever else they might be receiving, such as rental income. If you have something set up for them to receive rental income, of course, you have to stay within that limit of the governmental limits on wages that you can earn, which is, I think, $1,630 per month or somewhere around that amount. And, I think it's $1,651 per month. And so if the child, you can consider all that income in determining adult child support, and you also have to consider the expenses that the child would be responsible for. That includes home maintenance expenses, utility expenses, recreation, clothing, food, personal expenses, toiletries, vacations, computers, electronics, and then any legal or professional or caregiving expenses that might be involved in that child's life. So any pets that they might want in the future. Adding all these, it takes a lot to consider what the child might be expending money on in order to determine the level of adult child support that might be incorporated. And when you're talking about cars and electronics, you also have to consider the obsolescence of those. So you're not going to have one car for 60 to 70 years. So you have to consider that you're going to be replacing these appliances, these cars, these electronic equipments, furniture over the course of a lifetime. And that all has to be incorporated into that analysis. Other instruments that trust instruments to consider in divorce, as I touched on earlier, would be for the first party trust. Now that is an irrevocable trust. So if you develop that trust during the divorce process, it cannot be changed. If you, it is irrevocable. So it is required for first party for any adult child support. So this self-settled trust or self-funded trust or D4A trust, it goes by many different names, is recommended for the adult child support so that you don't lose the government benefits. Also, if the child was awarded a personal injury in an accident, that award would go into a first party trust as such. Also, the other types of instruments to consider would be a third-party trust. So for any inheritances from grandparents, any gifts from other relatives, rather than give it to the child who's receiving government benefits to preserve the government benefits, it should go into a third-party trust or a supplemental trust, as it's called, a supplemental special needs trust, a special supplemental needs trust. A third type of instrument that might be used is what I mentioned earlier, the ABLE account. It's a federal government account that might be used. And the reason I'm bringing that up is that there's a way to allow your child not to be supported at $794 a month on housing and food, that the government says you cannot give the child any more money beyond that for housing or food if you want to receive that government benefit. You cannot give it to them in kind, you cannot give it to them in cash. However, there's a way around this. A special needs trust cannot pay for housing or food, but the special needs trust can be funneled at $15,000 a year into an ABLE account. The ABLE account then can distribute for a better quality of housing for the child, because the ABLE account is broad. They allow you to have all kinds of, at this point in time anyway, they allow you to use it for all kinds of things, for vacations, for haircuts, for whatever you want for the child, including housing and food and going out to eat. So the child it can be used for payment of those types of things if it's funneled through the ABLE account. Now, that has to work within the gift tax exclusion. The child can only receive $15,000 a year in the ABLE account. So you can't funnel your child support that way unless your child support is only $15,000 a year. But potentially you would have another vehicle in order to increase the standard of living for your child throughout their lifetime. I have to suggest or mention that the first party irrevocable trust, in which the adult child support would go into, or any awards from a personal injury, that is a clawback trust. That means that Medicaid, that pays for that umbrella, that pays for all those things a child might have benefited from the day they were born, not from the day that you started the trust, from the day they were born to the day they die, Medicaid can come back and claw back anything remaining in that trust at the end of the child's lifetime. With a third-party trust, the special supplemental needs trust, they cannot do that. That can be left to other heirs. So it's not a clawback trust. It's not a payback trust, as they call it. So the different trusts are first party, third party trust. The first party is a payback to Medicaid. the third party is not. So it's very important that the way the MSAs are structured, the way adult child support is structured, the way anything is structured in division of assets, that you consider what will happen at the end of the child's lifetime with the aid that's been received through the child's life. The adult child is the owner of the ABLE account. One parent can be the authorized representative. So once again, you need to select a parent who's going to be the authorized representative. And that is probably another discussion of conflict and issues. I have a client right now who is co-conservator with her ex because they did that early on, and they became co-conservators, and then they divorced, and now they're she wants him off as co-conservator, and probate court, fat chance they typically do not remove conservators in those situations. They do not like to do that because then the government is in charge of establishing somebody. So be very careful about going on, suggesting or working with the estate planner and defining who's going to be the conservators or co-conservators or guardians or co-guardians or authorized representatives or IEP team member, and it can only usually power of attorney, one person, or healthcare power of attorney. This all has to be possibly mitigated during the divorce or mediated during the divorce process. Moving on to the use of a third-party trust. This is critical for the division of assets if you're going to set aside a chunk for the child for the future, or you're going to set aside your retirement plan or for the family. So however you're working with the family in order to divide those assets, to really consider what the MSA is going to stipulate regarding third-party trusts. Typically, they're testamentary trusts. They're done at the end of your lifetime. You say, I've got this, I'm leaving this amount to this child, I'm leaving this amount to a third-party trust, a special needs trust for this child. When the child dies, it goes to the other siblings. That's typically the way it's done. But you might want to stipulate that both parents will do that with X dollars or whatever it might be in the MSA for that child, so that the child is cared for beyond their death, beyond the parent's death, throughout the rest of their lifetime. And it will preserve government benefits if it's in a third-party trust, and it will not be clawed back. So those are all things to be considered, and it involves definitely an estate attorney to work through those issues, potentially during the time of divorce. And then there's in the third-party trust and in the first-party trust, there are many different roles to be defined. You might want to involve a trust committee because you may not be in agreement about that. You may have two separate third-party trusts. That could happen as well. So the child could have, you might need to stipulate accountants and record keepers and public benefits advisors and guardians and life coaches, and all those can be stipulated in the third-party trust. The third-party trust, if it's done during your lifetime, is not irrevocable. If it's done up a testamentary, it would be irrevocable. So to wrap up, there are many considerations in family law regarding special needs children and special needs families. Special needs definitely exacerbates the emotional toll of divorce. It exacerbates and implicates the financial involvements. The parents might be entangled for life. It might involve third parties, not only for a minor's counsel during the time the child is a minor, but also throughout the lifetime, who's going to arbitrate and who you're going to use for that. It stems from temporary support to permanent support. It involves division of assets and use of trusts for benefits planning, for conservatorship considerations, etc. And it also is, it involves settlement considerations, not only for the now, but also for the future, for three parties, not just the two who are divorcing. So there are many implications of special needs within divorce, and I hope that I've given you kind of an overview of all of those different domains, and I'm open to questions.